This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why insurers need to act to defeat insurance fraud, and why GEICO and its various entities continue their proactive actions against insurance fraud. And GEICO filing RICO suits against fraudulent medical providers is working to deter and sometimes even defeat insurance fraud in the state of New York. Insurers have found that states like New York will do little or nothing to deter insurance fraud. They have determined to protect the assets of itself and its insureds, so that many GEICO brand insurance companies have acted proactively against people and healthcare providers who are attempting to defraud them and their insureds. In a case entitled Government Employees Insurance Company et al. Versus Colin Clark, M.D. et al., a decision of the United States District Court for the Eastern District of New York on June 20, 2024, the fraud perpetrators and defendants of the GEICO suit attempted to defeat GEICO's activities and did so by counterclaiming that GEICO had committed fraud by suing them. GEICO moved to dismiss the Clark defendants' counterclaims and to strike 12 of their affirmative defenses. GEICO had sued the defendants for submitting allegedly fraudulent no-fault insurance claims to GEICO for services performed at Dr. Clark's health care practices. Among other things, it had brought claims for civil RICO violations, common law fraud, and unjust enrichment. GEICO also sought a declaratory judgment that the Clark defendants have no right to receive payment for any pending bills submitted to GEICO. In response, the Clark defendants counterclaimed against GEICO on allegations that GEICO has, through its insurance claim verification process, committed fraud by reporting Dr. Clark to the New York State Department of Health and by bringing 2 RICO cases against Dr. Clark, including this lawsuit. The Clark defendants counterclaimed for 1. Common law fraud, 2. Aiding and abetting fraud, 3. Breach of the covenant of good faith and fair dealing, 4. Violation of New York general laws, 5. Abuse of process, 6. Attorney's fees. GEICO moved to dismiss all counterclaims and to strike 12 of the Clark defendants' affirmative defenses. Under New York law, the elements of a common law fraud claim are 1. Material misrepresentation of a fact, 2. Knowledge of its falsity, 3. Intent to induce reliance, 4. Justifiable reliance by the claimant, and 5. Damages. Here, the fraudulent conduct the Clark defendants allege is simply the non-performance of GEICO's contractual duties to process no fault and regarding the alleged thefts committed by the K defendants, who apparently stole the money paid by GEICO to the Clark defendants, and GEICO's alleged non-disclosure of those thefts. Since the Clark defendants' conclusory allegations are insufficient to plead a claim for fraud, and because vague and conclusory allegations that a defendant committed theft are insufficient to plead a cognizable fraud claim, those claims were dismissed. GEICO argued that the Clark defendants' breach of contract claim must be dismissed because they have not alleged sufficient details about the underlying contracts or how their implicit duties were violated. The Clark defendants' conclusory allegations that they were assigned the contractual rights that GEICO owed to its insureds without any specific facts about those policies, when they were assigned, who they belonged to, what terms they may contained, or on what basis GEICO denied claims submitted pursuant to their terms. Absent even minimal detail about the underlying contracts, the Clark defendants cannot sustain a claim that GEICO violated the implied duties of good faith and fair dealing contained therein. Accordingly, that claim was denied. The abusive process claim, to that extent that the abusive process claim was predicated on this case or any other civil RICO action, the mere commencement of a lawsuit cannot serve as a basis for a cause of action alleging abusive process. GEICO's motions to dismiss the Clark defendants' counterclaims was granted. Accordingly, those claims were dismissed. Its motion to strike the Clark defendants' affirmative defenses were granted with respect to the Clark defendants' 3rd, 22nd, and 23rd affirmative defenses. It is denied in all other respects. GEICO's request to stay discovery pending adjudication of the motion was denied because it was moot. In my opinion, states like New York have made insurance fraud like that brought in the suit against the Clark defendants only to do little or nothing to prosecute the crime. GEICO, frustrated as a victim of fraud, has become proactive and works to take the profit out of the crime of insurance fraud. They and other proactive insurers are becoming successful in New York and other states, and either deterring or stopping in its tracks insurance fraud and gaining damages from the fraud perpetrators. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 4,800 blog postings. You can also subscribe to these videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble and the like button on YouTube. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.